Hello, so we're coming to the third part of our topic, easements. So now we're going to learn about the creation of easements. How can you create easements and what are the ways whereby a person can create an easement? So essentially you can see the charts here. So there are three ways whereby a person can actually have an easement. If it's either expressly created or impliedly created or by way of prescription, essentially by way of long use of right. So before I moved on further, so I've created a video for all of you to watch, a 2-3 minute video which sum up everything about on how can a person create an easement. So let's have a look. It's a Powtoon video. So there are four ways: by way of necessity, common intention, Wheeldon and Burrows, and section 62 of LPA. So this is the first one, easements of necessity. So I've given you an example. If a property is landlocked, so you have no access to go in, no access to go out. You also have a second situation whereby it can be implied if both two parties agree to it. So they have an agreement except it's not in a deed. So I've also given you an example of easement by way of common intention. So applying the rules, if you know someone is going to use it and without a particular right, you can't actually proceed with your work, then you can have an easement. So the third type of easement is easement created by way of Wheeldon and Burrows, or known as quasi-easements. So that's the third example. And the crucial characteristic of Wheeldon and Burrows is that you have one piece of land, but you subsequently divide it into two plots. So in such a way, you can say that you have an easement by way of Wheeldon and Burrows. So there are three elements for easement by way of Wheeldon and Burrows to exist: continuous, reasonable enjoyment, and must be used by the owner at the time the grant was granted. And the last method to create easement is by way of section 62 of LPA, it's a statutory provision, or it's also known as a wide-ranging provision. So these are the four ways whereby easements can be impliedly created.
Introducing Powtoon.
So consider this. So you have two plots of land. So the one who have direct access to the main road is Mel. But what about Clint? So without the right of way on Mel's house, he has no way to get access to the main road. Or let's say if he does, he has no access to enter into his property without the right of way of Mel's house. So in such a case, whereby a property is landlocked, he can claim that he has an easement by way of necessity, because it is necessary for him to have that easement. So if two people having an agreement and have written it down in a deed form, then that type of easement can be said expressly granted because it's written down in a document. But what happens is, let's say if you have an agreement between two parties, but it doesn't appear in a deed form, probably because it happens many years after those two parties have actually purchased the property itself. In such a case, even though if you have a deed basically saying that you own a particular type of estate, court can imply that you have an easement over that property, over someone else's property. So there are two types of impliedly created easements that you can have. One is impliedly grant, and another one is impliedly reserved for your own benefit, for your own use. So there, all four types of impliedly created easements can exist for implied grant. So means that whenever you have two plots of land, you sell land to another, so you can grant out that right to other person. Whereas if you want to reserve that particular right, only two types of implied creation of easement can exist, means by way of necessity and common intention. So you can't reserve an easement for yourself under section 62, you can't reserve an easement under the will of Wheeldon and Burrows, because it means that once you sell the property to other people, you cannot derogate back from your grant. So you can't give and then take back. So that's the reason why it only exists in two type of situations. So let's look through the first one. Implied by way of necessity, which can exist if you grant it out to others. It also can exist if you want to reserve the easement for your own usage, for your own use. So in the case of Wong and Beaumont, in this case we deals with ventilation. So court held that without that ventilation, so the other residents on the flat will have to suffer because of this nauseous smell. So in such a case, it is necessary to have ventilation. So in such a case, there was an easement of ventilation. So whenever you talk about necessity, it must be real necessity and it can't just be an alternative. Because if it's an you're talking about alternative route, alternative access, so it means that no easement can exist. So you can only have a license. So with respect to reservation, let's say if you own two plots of land, one land is landlocked and another one is directly facing the main road. So if you're occupying with the land that's landlocked, you can actually reserve the easement, the land that you've sold to the new purchaser, in order to allow you to get access to the main road itself. So these are the three cases that highlight, even though you have already sold the property to another person, you can reserve the easement for your own benefit, because otherwise you have no access to go anywhere actually. Alright, so this is the facts of the case of Wong and Beaumont Property Trust. So I'm just going to go through very quickly on what happens in the case of Wong and Beaumont. So you have a landlord who granted a lease to Blackbee for Blackbee to run a restaurant. So it comes with three covenants. So as you can see, is to run this restaurant as a famous restaurant, to make sure you comply with the public health regulation and make sure whenever you cook, you don't produce any of this type of smell. So obviously, Blackbee's attempt to run a successful business wasn't that successful. So you assigned the lease to Mr. Wong. So Mr. Wong converted that restaurant to become a Chinese restaurant and it was successful. So there was a lot of customers, so he cooked it constantly. But the problem is that whenever he cooked with this type of food, it produced this nauseous smell. So the tenant upstairs complained about it and they reported it to the public health officers. So one requirement or recommendation given by the public health officers is that to install a ventilation shaft so that the smell won't go through to the flats above the restaurant itself. But the thing is, the landlord refused to allow Wong to put the ventilation shaft. So Wong proceeded with the proceedings. He claimed that he has an easement because without this easement, means that you'll be breaching the covenants itself, all the three covenants in the initial agreement. So court held that the ventilation shaft was necessary, even though it wasn't stipulated in a deed, but the court can imply it or it is capable of forming subject matter of requirement. So he had an easement. So in this case, you can actually say that there was an easement can exist by way of necessity. Easement can also exist by way of common intention. So both ways can happen for in the case of Wong and Beaumont Property Trust. So next one is when you have an easement implied by way of common intention. So common intention is distinct from necessity because it's not necessary for a person to have an easement. But let's say if it's an intention of both parties agree to it, it's just that they didn't write it in a deed form, God said easement can exist. So here I give you a fictitious situation which have already been highlighted in the video just now. So applying the common intention rule, so if you have understanding between two people that without the electric cables, then you can't proceed with your work, God said that easement can exist by way of common intention. Third one, actually the third and fourth one is a bit complicated. Students find it very difficult to understand, but I'll try to go through very slowly to make sure that you understand how does it operate. So a person can also have an easement which is implied by way of Wheeldon and Burrows. Essentially it means that you have one owner who owns one piece of land. Subsequently, he subdivided it into two plots. So this is a characteristic that is very special for the case of Wheeldon and Burrows. So you have one owner with initially one land, and subsequently he divided into two plots. So like in this situation, the owner has divided it into closed field and away field. So in order for you to claim that you have an easement by way of Wheeldon and Burrows, so you need to prove that prior to the transfer of one plot, let's say in this example, the owner is McAdams. McAdams owns closed field and away field, and subsequently he wants to sell away field. So the new purchaser of the away field will be claiming whether or not he's entitled to the tract on closed field, whether or not there was an easement by way of Wheeldon and Burrows. So in order to determine if that purchaser is entitled to use the right of way, the first one, he must show proof that immediately before the transfer, quasi-easement was used for the benefit of what now becomes the dominant land. The land of the land of away field, this particular land. This is the dominant land. So quasi-easement basically means easement which has previously enjoyed by the landowner. So it means that you have one plot of land. Usually you can just use one plot. When you divide it into two plots, you still enjoy the benefit on the subservient land. So the second point is that whenever you talk about the quasi-easement, the easement which has previously used by the owner, it must be continuous and apparent. Continuous doesn't mean incessant use, it means that you need to use it every day. As long as you can use it every other day, you can show that you continuously use it and it's apparent to everyone, to the neighbors, then you can say that you satisfy the first condition of Wheeldon and Burrows. So in the case of Millman and Ellis, so you have the evidence of layby was covered in tarmac. It shows proof that the use of the right of way was continuous and apparent. The subsequent elements that you need to prove is that the quasi-easement must be necessary for the reasonable enjoyment of the dominant land itself. So you must say that without the right of way, then the particular land, the one that has been sold to the new purchaser, will be landlocked. So it is necessary for the enjoyment of the dominant land. In the case of Willis and J.J. Saunders, it says that the easement of way was not necessary if you can show proof alternative route. So court will also look into account the inconvenience caused by the subservient owner. So apart the three criteria proof under Wheeldon and Burrows, so you must also remember that you need to satisfy the Re-Ellenborough criteria itself. So if you satisfy the four characteristics under Re-Ellenborough criteria, then you can show proof that you satisfied the three criteria under Wheeldon and Burrows, then you can say that you have an easement by way of Wheeldon and Burrows itself. Unless it has been expressly excluded, then you won't have any easements. It's only a mere license that can be granted by the previous owner. So you need to remember that this rule does not apply to implied reservations. So when the owner sells the property, he can't reserve it for his own benefit. So it's only available for implied grant type of easement. Okay, so that's the ticking time. You can have a look later. And the last way whereby you can impliedly create your easement is by way of section 62. So under section 62, it stated out all types of rights whereby when you transfer it to the new purchaser, all these type of rights will be converted to become an easement. For example, when we talk about a license, once you sell the property to the new purchaser, that license will become an easement. So that is why if you read the textbook, it says that section 62 is actually word saving provisions. It means that it's all conclusive. It's like everything that's not listed in the statute or cases can fall under section 62 of LPA. So the case that applies section 62 is the case of Wright and Macadam. Just now as mentioned about Mrs. Macadam in using the garden shed to store her coal. So in this case, because initially she had a license, but when the license was renewed, so when the lease was renewed, the license to use the garden shed has converted to become an easement. So that is why it says that section 62 LPA is very wide. So it means that even though you initially have a license, remember license can be revoked, but it can be converted under section 62 to become an easement. The same goes in the case of Goldberg and Edwards. So in this case, we're talking about properties which has been leased, and you have visitors using the right of way merely as a license. But when that property has been sold, when the property has been renewed, so in the new list there was no express mention of the hallway, so means that you don't know if you have a right or license to allow the visitors to continue using the right of way itself. So in this case, he uses the argument of Wheeldon and Burrows. Court held that it failed because it was not necessary for the enjoyment of the building itself or the right of way. But applying section 62, court held yes. Goldberg actually won the case. Goldberg can claim that annex, that right of way, the adjoining properties, had an amount to an easement. So as such, the visitors can continue using that path in order to get access to another building. So it falls under section 62. So what should the landlord done in both cases, Wright and Macadam and Goldberg and Edwards, to prevent easement from arising? So the moral of the story is, if you don't want your license to be converted to become an easement, you need to specifically state in the deed itself, or to begin with, you don't give a friendly permission at all, just to be on the safe side. Okay, with respect to this slide, in the old times, we have old cases, you will come across all these old cases while reading the textbook, that in order to show proof that you have an easement by way of section 62, you need to determine that you have prior diversity of occupation. Essentially, it means that you must have previously owned the estate and you have been using that easement. But in the case of Platt and Crouch, court held that even though you have no estate in land, you only have a license. So under section 62 basically will overrule all the old cases. It means that as long as you rely on section 62, you have a license, the license can be converted to become an easement. So in this case, because the owner of the hotel sold it to the new purchaser, obviously the new purchaser would argue that they have an easement, essentially to include the rights to more boats. So in this case, the right to more boats by the hotel guests amounts to an easement. Alright. I've also prepared a chart to compare the differences between Wheeldon and Burrows and also section 62. So under Wheeldon and Burrows, remember that one special characteristic is that you have one owner with initially one plot of land and subsequently he subdivided it into two plots. That is where the rule of Wheeldon and Burrows will be applicable. But with respect to section 62, you have two plots of land and it operates where the land was in separate occupation. So two plots of land owned by Mr. Adam and Mr. Benjamin. So then you'll end up selling the dominant land, and whether or not the owner of that new dominant land is entitled to use the easement on the subservient land. So there are other elements as well. For Wheeldon and Burrows, remember the three criteria. You must show proof that it has been used continuously and an apparent and reasonably necessary for the enjoyment of the land, and it must have been used by the owner previously before the conveyance of land. Whereas under section 62, remember it's a wide saving provisions, anything can happen. Okay, so I'll stop part 3 of easements here, and I'll continue easement resulting from prescription in my next video.